time may be given, otherwise it will further prolong. Just because I do some time for completion of trial, some limited time.
We will not. You tell the trial judge. Tell the trial judge.
Then of course we will tell, but your lordship, without direction of this honorable court, it will
They have, in fact, the High Court has deprecated that act of the IVO.
not obliged.
Thank you. Item 6.
My lord, it may be taken up next week. As the arguing counsel, some personal difficulty, he has gone to his native place for performing last rites of his father.
So I'm also requesting a week accommodation to file counter affidavit. We'll take instruction whether it's cooperating or not.
Joint request list in the 4th week of January.
Much obliged.
Item 101.
Lords, I appear on behalf of the appellants. Your Lordship may recall that in the previous date of hearing, Mr. Raghav Shankar, the ASG, was marked in this matter, but due to conflict, he had to recuse himself. I've just received instructions that the matter has been marked with Mr. Dwarkanath, but the matter has been marked just today, so we just humbly request for an accommodation.
2009. Year in which I came to be elevated. And still you are grouping in the dark. What is this, sir?
Lord, our agreement also is over. The power plant also is over. I don't know if next week is going to be miscellaneous. But I can't object if the council is just changing.
At request of the learned counsel appearing for the petitioner, just immediately after vacation. I think it will come up in 2nd week of January.
No, 2nd week of January. Obliged.
Much
Great.
Item 102.
I don't think I miss.
Also. Item 103. 103. You are appearing for?
Respondent may rest.
I'm seeking some time to go through the documents.
No, please.
Reports have came, Elizabeth.
Other than time you ask for anything, will grant you. 2011, even after 15 years, if we are not disposing of these criminal appeals, by accident it has come. This was notified 3 days back. Yes.
Well, let's pass it over.
Pass on. 104.
The last date of hearing might recall the record of the Juvenile Justice Board.
Which one?
In this matter, my lord.
In this with which matter?
103.
103. Over. Next. 104. Item 104.
Respondents wanted to seek for an adjournment.
So you are asking, petitioner is asking for adjournment on behalf of
Just waiting for them.
I'm in 104.1, Your Lordship. I had a request for adjournment. My senior is unfortunately out of town today. But I was told that in 104, I'm told there was supposed to be a request made that it was.
Well, I appear in 104 and 104.1. I don't have any instructions regarding adjournment, but I will not object it.
You are appearing for whom?
I am in
But I appear for the appellant, Millet.
Huh?
104.
I appear for the appellant.
For the respondent.
You are appearing for whom, sir?
I appear for the appellant, Millet.
Huh?
I am not objecting to the adjournment, but I have no instructions regarding this.
You have no instructions for conducting the case.
No, I don't have instructions regarding the adjournment, Millet.
Adjournment, you leave it to us.
I am obliged.
104, you are appearing for the appellant.
Yes, Millet.
Huh?
104 and 104.1.
please proceed. 2010 matter.
Yes, Milord, it's a very short matter, Milord.
Yes.
The issue is the classification of the imported product Exol hexane RD, which should fall under category 27, but has been categorized under chapter 29.
Yes.
Lordship,
That
if
is
your
the
lordship
complete
is here,
issue
can
in this
I
matter, Milord.
make a request for a pass-over?
No, get your senior. You be here, take down the notes. Or you get your senior or your colleagues, whatever, whoever it is.
Lordship, then can I come back at 2 at least?
Sorry?
Can I come back at 2, Lordship?
No, don't come back at 2 o'clock.
I'm trying
By the time you would have finished the matter.
to call them, Your Lordship.
Huh? Do whatever you want.
Can I make a request then, Your Lordship, may keep it next week? I'll be.
No, not at all. Sorry.
I had briefed Your Lordship, unfortunately, in town today.
Huh?
Because I had briefed a counsel.
Huh.
Unfortunately, traveling today is why I'm not able to.
That's not a ground at all. No. Assist the court. Only issue, whether chapter 27 or chapter 29.
Exactly, Milord. That is the only issue.
And Sestat is held in your favor.
Yes,
Milord, Sestat has only proceeded based on the DGFT circular, Milord. And that circular only barely says that hexane falls under chapter 29. That is the only consideration they have taken. Whereas,
What is the basis on which you say it is chapter 27?
multiple lab test reports, which the first thing is chapter 29 is only applicable to single molecule petroleum products. Whereas chapter 27 is a mixture of all of them. And
Where did you get chapter 29?
I will just take my lords to.
These old hearing matters will have to act tough, otherwise no, this will not go on. 15 years, 16 years.
Lordship, may keep it back tomorrow then.
No, please.
I'll be ready for it. I am attempting to contact my counsel if he can log in by VC, which is why I made a request for 2 o'clock.
By the time you will be arguing. Where is the chapter 29?
My lords, I am appearing on behalf of the respondent in lead matter item 104, pure
Yes.
chemicals.
Yes.
My lords, the monetary effect in the matter is 45 lakhs. However, the monetary limit has now been revised to 2 crores in case of customs matters for departmental appeals. My matter may
Where is the tax demand?
duty demand is, my lords,
Where
45
is the
lakhs.
duty demand? Where is it?
My lords, in show cause, there are 2 show cause notices in the matter. One is show cause notice dated 17th of May 2004. That is annexure to counter affidavit, page 113 of counter affidavit.
They have produced is at annexure P1 in 104. What is the total tax demand? Duty demand? ₹56 lakhs.
I'm sorry, my lord, I was not well. This 104, I was not well, my lord, so I requested time. Other side also, I was told he was.
Sorry, we are refusing the time to both the sides. Only ground is, Mr. ASG, they are saying that the duty demand is, even according to your show cause notice, 104.1, it is 3697 plus 2,54,000 plus 159 differential duty. So it will be 150
It will
plus.
be less than 2 crores, my lord, but on classification issues, my lord, under the exception.
We'll keep open that.
It's for your lordship, my lord, I can't. In the second one, it is much less. That is the case, my lord. I can't withdraw is what I am submitting. The circular is clearly telling that on classification issues, we have to contest.
Having regard to the monetary limit fixed under the extant circulars which governs the issue, that the tax, the tax demand in the instant case as evidence from the show cause notices issued prior to the passing of the orders in original, reflecting that the tax demand is less than 2 crores. Keeping open all the question of law, the appeal is dismissed on the ground of monetary limit. 104, 104.1.
Lordship may not say circular.
Huh?
Lordship may say we refuse to decide the matter.
Okay.
Instead of circular and.
No, we'll say in view of the circular dated so we refuse to entertain the matter. What about under 4.2?
And 4.2 is what he wanted time, second matter.
What is that? You tell us.
But there I think it is above me. Reliance Industries.
Show cause notice 194.1. Who is appearing 104.2?
Mr. Shashi Prabhu was there, not he said I will take time.
4.1. That Raju is asking for 4.2.
We don't have a polyglot. After the short call,
Same issue?
yes. This is more minutes, 23.85. 20.2 is more. That's may turn to page 248.
Huh?
248.
248.
That's the operative portion of the order. 28C. 28C and D para. Above 2 crores. Para 28C and 28D and page 48.
23 crores.
Yes.
And again 7 crores.
Yes.
Penalty limit. Who is appearing for the respondent?
Seeking some time for answers in this matter.
Other than time, you ask anything, madam, we'll give you. You want to argue till 4 o'clock, we'll give you. Except time. These are all issues which are pending from 15, 16 years.
My friend told me that he'll be taking time, and I was also not well. That is the reason why I'm. And in fact, I told another panel councils to be ready.
Okay, you take time from them.
No, I don't take. I only said he was not well, and incidentally, my lord, I am not well today also. That is the problem.
This is emotional blackmail.
No. There is no emotion, my lord. Because of the bad weather, my lord, I am hit. That's the problem.
In fact, speaking for I am not well from past 1 week. 1 week.
I can't deny it, my lord, but
Despite that, in fact, we. Okay, I will not say. Huh? Same product. Is it here? Immediately after report. Yes, next.
obliged.
Continue.
For the 3 matters. List of
All list of
3 matters.
Only 104.2. 104.101 and 104.1 disposal.
Item 105. The appellant in 105.1 has passed away. With the manager of the school, incumbent manager.
I'm not able to hear you, sir.
Yes, appellant is on item 105.1. Manager of the school. Raju, he is the incumbent manager of the school.
He is the fourth respondent, my lords, in that 105.
What? So you're only a principal.
He is the manager, man.
Huh?
He is the manager of the school.
He is the beneficiary of the order.
My lord, he was the one who passed the order. I am the beneficiary.
No, appointed.
He is the appointee.
So only a change of principal, that's all.
It's a change of, my lord, manager.
Now, who is challenging this order?
My lord, sir, I am challenging the order.
You are the beneficiary and you are challenging the order.
No, my lords. In fact, I am the appointee by the manager, which was set aside, my lords, by the learned single judge as well as the affirmed by the division bench. Hence, my lords, my essay.
My lord, sir, I am appearing for the first respondent, my lord, in all the matters, my lord. My lord, due to a personal inconvenience, my lord, due to the marriage of my son, my lord, I pray for a short adjournment, my lord. I'm
Released.
Item 106. My lord, also kindly observe the incumbent manager may be seated.
You do what? You file application. It is reported that the appellant number?
First appellant in 105.1.
105.1. First appellant is said to have expired. Necessary steps be taken to bring on record the present incumbent. It's 106.
Obliged.
Item 106, my lord, this is the case of 302 as well as I am for the accused father-in-law, mother-in-law and husband. My lord, this is the case, my lord, would be in alternative 302 IPC and 498. Trial court convicted in 302, life imprisonment, all three, and 2 years in 498. But High Court acquitted in 302 IPC, but convicted in 498 IPC. And with the observation, my mother-in-law, while that time undergone more than a year. So
period already undergone. What about the husband?
My lord, husband, by the time he has completed 13 years, more or less 14 year sentence by that time. We have custody certificate. So husband is also acquitted in 302 IPC.
That's
But by the time this judgment came by High Court, that he has undergone, my lord, almost 14 years. And my lord, we have filed this SLP due to the reason that father-in-law was employed in land acquisition department as assistant engineer. Due to the conviction of 498A, these all retirement benefits were taken off. So we filed this SLP again, my lord, complainant filed against the order, then this SLP was tagged. And the state has also come after that. So these are the three appeals. I am in the main appeal accused for the accused, and again 2 appeals by the complainant and by the state.
How many 3 appeals?
These are 3 appeals.
That's right. State has also filed a case.
The state and complainant have filed after a huge delay, my lord. They have come, but matter was tagged with this matter.
106 is
Yes.
by whom?
By the father-in-law.
This is father-in-law. This is my appeal, my lord.
Only father-in-law.
Only father-in-law.
106.
Yes. My lord, this is covered by 3 dying declarations, basically 2 dying declarations, 161 statement. All are different. All are contradictory to each other, my lords.
6.1 is by the complainant.
No, 1 second. It's not technical glitch.
Complainant has not come, my lords. My lords.
106.1 is by?
By the complainant. He's the brother of the deceased.
He brother of the deceased. He is not at the time before.
Brother of deceased.
Yes, sir.
6.2 is by the state. We're challenging the order so far as 302 is concerned, the acquittal by the High Court under 302/34. We say it's a murder. State is in. Now these 3 are listed together.
Wife died, my lord, after 7 days after hospitalization.
What does she say in her 161 statement?
My lord, if my lord allow me, then I will start it.
Have you prepared any synopsis?
Yes, yes, my lord.
Next to the P4, if I may assist.
My lord, if my lord can see this.
P4 is the one.
My lord, this is the synopsis written submissions.
What is that? What did you say?
P4, Manas, in one of the appeals is the 161 statements of the deceased.
Oh.
This is treated as a third dying declaration.
I want this copy and I will just give you photocopy to all. I also need 1 copy of it. This is the only copy which I have right now.
How would you argue without you are having?
This is written submissions.
This is written submissions, my lord, the form is my lord's. For the convenience of my lord, this matter was taken up in 2021.
For 2 honorable judges.
My lord,
One copy.
I was not prepared that I was not expecting the matter
Then,
to come.
yes.
Yes, I will give. I will.
So still the husband is inside or is on?
No, my lord, he is released.
Released.
Yes.
After completion of the sentence.
After completion of service by the order of High Court, as he was acquitted in High Court, my lord. And by the time
he has not challenged.
He has not challenged. Only challenged by the father-in-law due to the reason that retirement benefits.
Mother-in-law, number 3. Mother-in-law.
Mother-in-law.
No. Only father-in-law challenged.
Mother-in-law also accepted. She has also undergone.
She has also undergone accepted due to the reason of retirement benefits. My lord, even this photograph original.
Only 498 is no 3 and 4 of DP Act.
My lord, this alternative, sooner before her death, there was no demand, authority demand. So the alternative, there was a charge in 302. And 302 was taken up, not 302. This is the current custody certificate by the of husband, my lord, if my lord will we have recently. My lord, Annexure P1 is page 33 in Nagendra Singh, the first appeal 302. This is first dying declaration.
Page?
Yes, 33.
That is before Naib Tahsil.
This is before executive magistrate. Question number 4 is relevant, my lord. Cloth was stuck into mouth and kerosene oil was poured over the body and put on fire with majesty. And question number 2, who had burnt you? My husband, mother-in-law, and father-in-law. Second dying declaration by my lord.
Question number?
Question number 2, my lord. Second and fifth relevant, my lord. Question basically number is not mentioned. This is question. Second dying declaration before Deputy SP. My lord, it was requested by the husband that he was looking that many persons were there in the room and hospital. So he requested SP to take another dying declaration. This is second dying declaration by Deputy SP. Page number 35. My lord. In this, she said, I myself had poured kerosene oil and put on fire. My Devar Shailendra tried to save me. And I had regular quarrel with my husband and my mother-in-law and father-in-law were taunting on me. Stated that they were torturing me. They demanded Maruti car from my parents. This is an incident of 2001, my lord. 26 years back. This is 161 statement on page number 39. I will allow me go through 161 straight.
All right.
Page 39. This wife is also qualified as PA MPhil, my lord. Husband is also MPhil. Stated that page 39, lord.
One.
Page 39.
Date of incident. What is the date of incident?
15/4/2001. Bullet point of this case, my lord, that he was voted from his side.
Date of incident 15/4/2001. And what was the date on which the 161 statement?
20th April 2001.
20th April
2001.
And first dying declaration?
16th, my lord, 16th April.
And before the Deputy Superintendent of Police?
17th April. FIR on 18th April. I-06 and 498A. That time she was alive.
FIR was on 16th.
Yes, my lord. First was 16, 17, second declaration, FIR on 18th.
FIR was on 18th.
Yes, my lord. Under section 306 and 498A. That was time she was alive.
306 and
498A.
No.
307.
306. Also. Suicide, my lord. Suicide.
No, attempt to suicide.
Yes, yes. And page number 39 is a
she was alive.
Statement on 20th April. Different dates of every 161 is also on 20th April. My lords, in the mid of the paper of page 39, it is mentioned, since then he is not talking with me properly.
Where are reading?
I am in the mid of the paper. I start
Statement 161.
161 statement. My lord, this is the 7th line from the top. Now you bring a car from him for us.
Page.
Page 39. In first appeal, Nagendra Singh.
Read it from the beginning.
Yes, my lord. It stated that I am MA passed and I am doing PhD. I was married with Nagendra Singh about 11 months ago. He remained very well in matrimonial house. At that time, the behavior of my husband Tillu, Nagendra Singh, father-in-law, Narendra Singh, and mother-in-law, Leela Singh, got changed, and they three told me that your father is such a crook man that he had not given a Maruti car in dowry. Now you bring a car from him for us. For last 4 months, they were harassing me too much. In the meantime, my husband had gone to my parental house to bring me back and quarreled with my father on this issue and brought me back. Since then, he is not talking with me properly. All of them were criticizing. On 15th April 2001, in the morning at about 6 a.m., I wake up and my husband also wake up and at about 6:30 a.m. As soon as I entered into the kitchen, my husband Nagendra Singh also followed me and took my dupatta, which I had put on me, and stuffed the same into my mouth. Then I gave jolt to him eligible. Then my husband took my dupatta and tied the same on my neck and a cloth which was lying there, stuffed into mouth, and poured the gallon of kerosene oil on me. In the meantime, my father-in-law Narendra Singh came into the bedroom and some portion which was not readable at that time. In the meantime, my husband put the fire on my body. With matchstick, I started screaming, and then my neighbor Shailendra came there and tried to save me, and then I became unconscious. I do not know as to when and how I was brought into the hospital. On 16th April 2001, when I regained my consciousness, then I gave my statement to Tahsildar Sahab and Dr. Sahab. My husband, my father-in-law, and my mother-in-law, with intention to kill me, had poured kerosene oil on me and put the fire on me. But it is very clear that she said, she was recalling her whole first statement, that I said to executive magistrate the name of three, but it is done by only one. This, on page number 41, this is Devar's photograph. We have original one also, Madam.
What is it?
This is Devar in saving her Bhavi. His Bhavi, he has got this condition. My lord, in 2001, only these photographs were allowed to black and white, so that. Medical report on my lord, page number, annexer P6, page 42, Dr. Mishra. And if relevant para is para 7 on page 44. Very well. Okay.
Yeah, read the relevant portion also.
Yes, if you can. If my lord say, then I can go through all the.
Which page?
Page 42 to 44. My lord, this is doctor's report.
Doctor's report or deposition?
Deposition.
In which he tells the injuries also.
After that, my lord, we have the statement of executive magistrate also and deputy SP statement also. They say that when they took the statement, first executive magistrate, then many members were sitting of family, sitting there of deceased family, and they say that you say this. This is the next, we have this also statement. Deposition of executive magistrate is also an another P7. I am going through, my lord, another P6. This is medical report. I am posted assistant civil surgeon in primary health center, Devlon, since 1998. I recognize accused Nagendra Singh, Narendra Singh, and Srimati Leela Singh on 15th April 2001 in the morning at about 7 a.m.
May I point out? So he's acquittal under 498A, wherein I am in appeal, wherein I am asking that 302 is a case of 302. So may if Maro suggests my
so all arguments are the same.
So
not she is hearing.
when I don't want to proceed in a certain fashion, right from the beginning.
What you are suggesting is if you are appeal, if you are accepting your contention, then his task will be appeal, more dangerous or more risky. Yeah? Right. But prima facie, no, we are not. Very fact that there were 3 dying declarations.
That's right. There were 3. There was perhaps no need of recording the second one.
The 3 dying declaration itself is a ground on which 302 cannot be sustained. So, number 1. Number 2, what is the MLR, medical legal records, which you produced? What are the exhibits? Number 1. Number 2. Number 3, what was her mental status as on the date of admission?
Yes, I'll answer all those.
Answer these 3. Then we'll examine whether 302 and who is for the complainant.
It is not available, madam.
It's not here.
It's not here already. We'll appoint someone as amicus, but there seems to be not interested.
Maybe, my lord. The last occasion he was also not there.
So, Manoj, may I quickly answer that? So, there are 3 dying declarations. One is on the very next day of the incident, which is reported by a magistrate, which has the endorsement. I'll show that and from the exhibit also itself. That was an endorsement of the doctor of giving the fit state of mind. She was having 51% of burn injuries. And then it is recorded by an executive magistrate in a question answer form in which she clearly implicates this.
Where is that?
Right.
So this is the first one which you read.
That's right. So Malod, this is.
My lord, let me complete it.
Wait, we'll hear him and then we'll come back.
Okay.
Right. So this is Malod's P1. This is the very DD. So the person who records
this is nice declaration.
33. Huh? This is 33.
Who has signed this?
Now
R.S. Tripathi.
That's right. He's the Naib Tehsildar executive. So Malod, so far as first DD is concerned, there is no problem. No, also this is
no. We have some problem.
Yes, I'll demonstrate.
P.S. Tripathi is the scribe.
Correct.
And witness is Nitin Das.
That's right.
What is mean by RSO surgery?
This is some.
Whether he was examined?
Yes.
Examined as PW?
He is examined as PW. I'll just tell. Well, RS Tripathi is PW 18, the executive magistrate, and 16. That is 16 is Mr. Dr. Nitin Das.
PW 16.
Correct. I can take the
one second.
Right.
Where is the second declaration?
Second DD Madas is
dying declaration is
P2 at page 35. This is not by any magistrate. This is by a deputy superintendent of police.
DYSP.
Deputy SP, DYSP. In which she says.
One second. Who is this DYSP? PW?
This is Malod's PW 22.
PW 22.
That's right. His name is K.L. Suryavanshi. This is recorded on 17th.
1 second. K.L. Suryavanshi.
That's right. Only.
And it is also countersigned by who is that? This is CMO GMH.
This is M.K. Tiwari. I just Dr. M.K. Tiwari, Manoj.
No, CMO is that means Chief Medical Officer.
That's right. This may not have been. I'll just confirm whether this.
We want these are the most important. We'll tell you why. Has he been examined?
Okay. This. Note down. This is Exhibit P30. I'm reading this. This is right. CMO GMH Riva on 17th 9:40 PM. This is record. Doctor is M.K. Tiwari.
PW?
This I'm afraid is not examined. I just confirm then. The first one was Exhibit P22. This is Exhibit P30.
There no index, nothing.
I can take one of PDF pages of the index.
One 61 statement is recorded on 24. Who is the person who recorded it?
20th, Manoj.
Sorry, 20th April.
So this becomes the third.
Who is that who has taken down?
Manoj, the
Only two statements. The two declarations.
24/2021.
Two dying declarations, 161 statement.
161 statement. All.
And here, my lord. Sorry.
So now take us
Manoj.
to PW 18.
That's right.
PW 16. PW 22. And what about this Tiwari?
Right. So Manoj may kindly have the trial court report. I can refer from the pages. Report. Manoj may kindly have PDF page 885.
We don't get PDF page here.
Was the printed page is page 81. PDF page of the TCR is 885. This is the
running page in that right hand side top. It is mentioned as 83, 84.
That's an 81.
81.
Manoj have 81. That it's Prabha Shankar Tripathi.
Witness number 18.
That's right, Manoj. This is the executive magistrate, and that's right, Manoj. PW8. Now he records the first dying declaration on the next day. May I read it, Manoj?
Yes.
Para 1. I am posted at Night Tehsil and Executive Magistrate at Tehsil so-and-so for the past 3 years. On 16/4/2001, I had recorded the dying declaration of Vijay Lakshmi at GMH Hospital Riva and received the requisition of the police in this regard. I made the doctor present here to examine Vijay Lakshmi in regard to her fitness before recording the statement. And I also got her examined after recording her statement also. The concerned doctor gave a certificate at the beginning of and at the end of the statement.
Who is this? I had made the doctor present here to examine Vijay Lakshmi in regard to her fitness before recording the statement. Who is that doctor?
The doctor is Dr. Nathan Das, PW16. PW16.
PW16.
Dr. Nitin Das.
All.
Because I would be heavily relying upon the first dying declaration.
That is this one.
This is this
one. All.
So he's the
Yes.
Para 4, Manoj. I had recorded the statement in question answer form. Vijay Lakshmi was burnt. I asked her how she got burnt. On asking this, Vijay Lakshmi told that her father and mother-in-law and her husband stuffed a cloth in her mouth, poured kerosene on her and set her on fire. Exhibit P22, this is the original, which is P1 and next is the declaration of Vijay Lakshmi. It is in my handwriting. The E to E part on it bears my signature. I kept the statement in an envelope after recording it and handed over to the in charge of the concerned police chief. Now he's been cross-examined. May I read the cross-examination?
Yes.
I did not write the order sheet in regard to the proceedings of the recording or dying declaration. I did not take the acknowledgement of the envelope after handing over the envelope to the in charge of the police check post. I had received the letter to the police on 15th. It was at 4 o'clock in the afternoon. On 15th, I had asked the police to give in writing whether Vijay Lakshmi was capable of giving statement, but the doctor sent this message that Vijay Lakshmi was not in the condition to give a statement, so I did not record a statement on 15th, which is the day of the incident. The doctor had given this information in writing in the letter of the police. Para 7, I had not attached any comment on the letter of the police. The envelope in which I had given the dying declaration, exhibit P1222, that the police check post is not produced in the challan today. I recorded Vijay Lakshmi's name, her address, her name, etc. After asking Vijay Lakshmi The doctor had not conducted the medical examination of Vijay Lakshmi in my presence, but only had conversation with her. Now, this is a comment of this Exhibit P22 that the doctor had conducted the fitness examination of Vijay Lakshmi by talking to her. I did not find it necessary. I did not write a comment because I found the examination conducted by the doctor to be sufficient. Para 9, there was some ladies present. Now, this I can. So there was some lady patients in the adjacent beds of Vijay Lakshmi. I do not remember their number. I do not remember whether Vijay Lakshmi was given drip or not. When I reached near Vijay Lakshmi to record the statement, a lot of persons were present near Vijay Lakshmi. About 4 to 5 persons were present there. When the recorded, I made the persons present in the room to leave the room. This is very important. Para 10. I do not remember that out of the persons who were present in the a lady while going out asked Vijay Lakshmi to give statement that her mother-in-law, father-in-law, her husband had set her on fire. But out of these persons who were present, somebody had talked to Vijay Lakshmi while leaving the room. So the trial court also discusses this. Para 11. But out of them, one person had to say that only what that person told her to the court. I know how the statement of the witness is recording the CRPC question. When you appeared in the recording DD, then you were in the capacity of magistrate, despite why did you not write a comment in this intent in Exhibit 22, despite of the statement being heard by some person by explaining the person whose DD was being recorded. I answer, I did not give a deep thought to that and explain that person giving statement to whether to state.
All this will depend upon her MLC, medical legal case records. Where is that?
So minus this.
Her what do you call it? Rip sheet. No, what is that? Case sheet. The moment a patient is entered in the hospital as an inpatient, they start writing these. 12 o'clock, checked her BP, checked her pulse, 180, 20, 160, 40. Her this thing is so.
That's
show it. The reason is this. We are asking you because where is the doctor evidence?
The reason, what the fact of the matter is, since both her hands were burnt completely, therefore the doctors did not record her BP. This is also discussed.
Doctor did not
record the blood pressure.
Might be
because her hands were.
They will write it. They will write it.
You will have to write it.
In the case sheet, it will be written. Pulse not able to be recorded due to burn injuries. Who is the doctor you said?
This is the Manoj Dr. Nitin Das, PW16.
PW16.
That's right, Manoj. So this is at page number 76 of the same. Manoj had it. PW16, Dr. Nitin Das.
Where do you get it?
76. Follow the same. Numbers were at some 80s page, just above. Page 76, witness number 16, Dr. Nitin Das of the TCR.
Page number?
76. Of the same document, just few pages above.
Oh, not that evidence.
What is the same document?
One second.
When Manoj were reading PW18, the executive magistrate, just few pages above that.
come to the deposition of PW6. Who is this Dr. Mishra?
Just. PW6, Dr. Mishra.
Ah.
So this is Malak. So Malak, may I briefly, the incident was, so she was taken to the Devlon Health Center and then from Riva. So this is the first doctor. This is the first place.
Come to that.
That's right. May I read Malak, page 53, witness number 6, Dr. Rajesh Mishra.
PDF page number?
This is PDF page number 857 of the PDF and printed page is 53.
First appeal.
Correct. Deposition of Sri Dr. Rajesh Mishra.
That's right, sir. May I read it? So, Devlon is the place where they first rushed to, and then from she was referred to Riva.
See, come to the
That's right.
first sentence. Second paragraph, first sentence.
I am acquainted with the accused Nagendra Singh, Naren Singh, and Srimati Leela Singh on 15/4/2001. At about 7 o'clock in the morning, the accused persons had brought Vijay Lakshmi to the hospital. Vijay Lakshmi was in burnt condition and unconscious.
Yes.
She was unconscious on the first day.
Now the burden shifts heavily on you. When she regained conscious, what was her mental status? Subsequent to this, because her 51% burn. So now you might be justified also in saying even 90% burn. She might be conscious and oriented.
That's right.
It all depends. It depends upon the patient. It varies from person to person. Show us from the medical records what was her condition at the time of recording of her dying declaration by the Nayab magistrate.
So
what time it was recorded?
It was the time I can just
11:25 a.m. 11:25 in morning.
11:25 a.m. to 12 noon. This is the next day.
Where does he record what time that?
Malot, in this first appeal, this is Annex P1, and on page number 34, it is mentioned in between 11:20 a.m. to 12 noon.
So where is that in the original? Where is it recorded?
In original.
The original, Malot, I can also show the original.
You are showing the PDF page number 8.
Yes, I can show the original also. PDF page 96.
In your, what is this? This is a typed copy, is it?
This is the typed copy. This
in typed copy, you need not mention what is mentioned in the original, is it?
So there may have been. So this is a better copy. If Malaj has this page 96.
How can you do this, sir?
Because it's actually there. Is the
96
used petition which is Malaj having also.
We are having the original records.
That's right. 96 Malaj. Page printed is 58. ECR page, PDF page 96.
96, no, it's only some deposition.
No, Malaj, this is the dying declaration itself.
Sorry, we don't have that. Our records do not. It is 897 PDF.
No, I'm talking about PDF page 96.
PDF page 96.
That's right.
Yes, it's in Hindi.
That's in Hindi.
Ah.
So if Malaj.
And what you have produced, the typed copy.
What he has produced.
Or what the trial court has sent it. We don't know who has given this page number. Take out page number 883 or page number 83. Most indisciplined way of conducting the case.
Because I'm sorry to have.
No, we are very sorry. because we are not used to such things. Wherever we have worked, the criminal matters, paper book used to come.
Index paginated.
Everything, part 1, part 2, part 3, part 4.
Yes, say this.
And the learned advocate used to give a chart. He used to give a chart. What PW1 has said, what is the oral evidence, what is the documentary evidence, what is the MO.
Man, limited experience, this is a much better TCR.
Huh?
Much.
No.
You feel this is much better.
Yes. Sometimes it's Hindi, not even English.
That is different. It's always the criminal trials are recorded in the local language. Absolutely, there is nothing wrong. Where is the time recorded here?
So Milos is having page 96. The
96.
Right side of the top of the page. Milos has.
Yes.
So reading on the left side of the page, it's 11:35 a.m. Patient is fit for dying declaration.
No, this is something. 96 of what?
So it's in handwritten.
Index is no index.
Index is also there.
No index.
But page number PDF 56 is the index. Hindi. Page PDF page 56 of the TCR is the index.
58. Here everything is 58. 6 page numbers they have written 39, 57, 10, 97, 108, 34. Hospital records are there. We'll see records. Was the case sheet not marked?
Case sheet I could not find it in the. This is only.
How can it be, sir?
Because the doctor would normally, parameters would endorse the parameters.
PW6 says that she was brought at 7 o'clock.
Yes?
PW6 Rajesh Mishra says that she was brought at 7 o'clock in the morning.
So this is, on the 15th, she was brought to Devlon, where she was unconscious.
Yes.
And on the next day, when she regains her consciousness, then the first day, next day, first day declaration is recorded on the next day. When she regains her consciousness, so the first thing what is it putting is that where is the endorsement to her parameters? My lords is having pages. Okay. May I take my lords? My lords may have couple of pages earlier. This is PDF page 93. There's no printed page on it. On the first day, there's an endorsement that she's not fit.
Whether this Dr. Madan Mohan Mudgal was examined?
Yes. I'll just go.
See, at the time of admission itself, whole face burned.
Yes.
Official burn.
P15 ones. He's P15.
Teeth burned. Lips burned. Kerosene smell coming from body. What does she say? What does she say about that stove burst or something? She said?
So I'm sorry, Mama. What?
That burst, she herself inflated. That is what she says.
In the second one.
Second one.
Yes. This 17th, in which she says the deputy SP, which she says the sheriff formula. I would not first.
Two things. One is she was burnt, no doubt.
That's right.
Two, there was kerosene and also emerges from the records.
That's right.
Three, whether it was the husband and in-laws who poured it or whether she poured it herself is the one which you have to clarify. Two, third one, she was in a fit condition to, that is most important because records disclose otherwise.
Because I mean, humbly submit, the endorsement of the doctor is very much.
That itself is not sufficient. It has to be corroborated by the medical evidence, MLC records.
So
You have to show it from the MLC records. Because
so far as the first time when she gets admitted, the doctor record says she's unconscious. Would my lords have page number 76 of the PDF? I can clarify, my lords, one by one in the chronology.
she was the first hospital she was.
Dave Lond. Dave Lond is a PM center on the first day.
Refer to Riva Hospital.
Then she was immediately referred to.
This is the first hospital.
I can tell the name, or the.
You tell us.
Dave Lond.
Dave Lond.
Yes.
How do you spell it?
Primary health center.
EVLOND Hospital.
Dave Lond Primary Health Center.
Yes, yes.
That's right.
On 15/4/2000.
15
Same day, my
on
lord.
the date of
Immediately
incident at 7:15 a.m.
At 7:15 a.m.
That's right. Malos page 76. I can just.
These shows from the original records. Where is this? Case history of 15/4 at 7:15 a.m.
I have it with me.
Shows from the original records. Flag it.
Golden Jubilee celebrations in Karnataka. We had very Saturday students. All these. 9 benches, looking about 18 benches. All divorced. Only taking one about it. So I was standing watching for years. Please, we cannot say no.
What was the hell? Yeah.
Then one second, please. Then she was shifted to which hospital?
Riva Hospital. Riva Hospital.
Riva.
This is main hospital in Riva. Riva is a district, my lord.
Riva District Hospital. Where is that medical record? Riva Hospital.
That precisely I could not find. So that becomes important because then we say that she was conscious.
So she was shifted to Riva Hospital. What time? What date?
Same date, immediately after primary health center.
Huh?
Doctor said that this is a serious case. You go to the
Shifted to the bigger hospital.
Yes.
So what time?
Couple of hours later, on
It was 7:30.
7:30. So this 15. So 15th there was no.
Recorded because she was unconscious.
See, 2001. Yeah. When she regained conscious.
Yes.
I follow you, sir.
The reason is this, Mr. Counsel. Normally in circumstances where the father-in-law and mother-in-law or the husband were to indulge in burning, they would not be in the vicinity of the crime and they would not accompany the victim. They will abscond for the fear of being arrested. Here it looks throughout they were there.
So what they say, the defense says they had gone for a morning walk, and so the incident is that the brother-in-law, PW1, hears shouts, screaming. He approaches the kitchen. So he sees the kitchen door locked from the inside, and then he cries, screams for help. So there are 2-3 neighbors who also join in, and then they barge open the door. Now they know there's another door in the kitchen. Now in the cross-examination, DW1 says that was also bolted from the inside, and there was a window which was open, the kitchen. So now what they do is that all of them come inside. Some pour water over her, and some.
How many persons were there when they came inside?
3 people, according to the
First examination.
In the kitchen.
In the kitchen.
In the kitchen.
Other than the victim.
Other than the victim, certainly the brother-in-law.
No, brother-in-law who enters along with the others.
Right. So there were. Mr. Baheria was there. 3 people were.
Who are all the who barged?
Even neighbors.
Huh?
Neighbors.
Who are they?
Hello. Why don't we note down the name? This is yes. One is Mr. Baheria.
Baheria.
G. Bheria.
Is PW?
He is not examined.
Not examined.
Not examined. The other is Prembai.
Whether examined?
Prembai, there's Premvati. What is this again? PW9, Manoj.
PW9.
There may be a.
And that brother-in-law?
And brother-in-law is DW1.
DW1.
Right. And then there's another.
What is the name of that brother-in-law?
Shailendra Kumar.
Shailendra Kumar. And PW10 also. So this is Shriman.
One second.
Right.
DW1. Who is the other one?
Malad, sorry, Shailendra Singh.
1 second, sir.
PW10.
PW10.
Umar Khalid.
Umar?
Khalid.
UM. So
Umar Khalid. KGER.
KEER. This is PW10.
All right.
So Malad.
1 second. These 4 persons who entered, only 3 you have examined.
Only
3 are examined. So in these 3, do they say, other than the victim, anyone else was present inside the kitchen?
No, they don't say so. No, so far as the presence of the other accused persons, they say that they were not there. On the contrary, they say that then when they shifted the body in the courtyard, then they saw that the mother-in-law, father-in-law, and the husband, they then
entering. Yeah. So that goes to show the story put up by them is in the proximity of truth.
So what they say is, the presence. We are talking about the presence of the accused on the spot. So there was what I would argue was there was another door.
So according to you, they have put her on fire, lit her, escaped from the other door.
Why would she tell a lie? She's
in that event. Does she say that she has closed from inside?
She does not say anything about.
Then
she does not say anything about the door. Now, the fact of the matter is
very.
The first time declaration, her fit state of mind is recorded in which she.
Second statement. The doctor says, Naib Tahsildar, he says, there were other persons, someone told something, I don't know what she said, and then when she left, the other person also said, say whatever he has said.
But these people are not identified, we do not know these people.
Who is appearing for the complainant?
On the last occasion, my lord, he was not there even. Last occasion was also not there. But not.
Mr. Mrinal will argue on behalf of the complainant and Wakalatnama.
Sorry?
Mr. Mrinal will appear for the complainant.
Mr. Mrinal.
He has to file Wakalatnama, she is saying.
File it, argue the matter, that's all. Absolutely not. We have spent considerable, more than 1 hour on this. We will not give you even 1 hour time. We are making it very clear. If you want, we'll record it and we'll show that, we'll say that you have not been cooperating with the court. We'll be inviting trouble, madam. See, normally we are liberal. See, if you want, you should have asked the time in the beginning. You cannot just barge in at the convenient time to you and say, I am filing one, you give it. You don't assist the court, don't assist. That's all. We'll ask someone to be the amicus. We'll record your non-cooperativeness.
Sir, you've been recently instructed to appear.
That is between you and your client. We are not concerned about that.
Cannot be appointed.
Sorry?
So my case cannot be appointed till I lunch now.
Then you assist. During lunchtime, take the file, study, come, assist, we'll welcome you. You may accept your contention, we may not accept your contention. Absolutely no. We have spent considerable. This has to end today, either this way or that way. After having spent so much time, there are 3 appeals, madam. That is why. Please understand, please cooperate with the court. We request you with folded hands. Understand our difficulty also. Having spent so much time.
May I interpret?
No.
Very well.
At present, as of now, you are safe. Wait. So the second hospital, that is Reva Hospital.
That's right.
Medical records are not there.
Not there.
2. 3, the doctor who is examined, Nayab Tahsildar who recorded that 16-4, he says that so and so.
They were asked to walk out and then while going.
3, the doctor who initially examined,
Dr. Mishra, Rajesh.
Dr. P.S. Mishra,
Ji.
he says she was unconscious. And the medical records also shows she was unconscious. When she regained consciousness, that is not forthcoming from the medical records.
That should have been, perhaps, I could not lay my hands on it. So
You close.
because
You may be wrong.
because this so far as this is in line with the statement of the doctor that she was in the fit state of mind, and then she also says that I could not measure the blood pressure because her
Might be.
hand
If
was
20% burn also, there may be instances where the patient may be disoriented. There may be cases where 90% burn, still the patient may be oriented.
burned.
It all depends upon that particular patient. It depends, it changes.
That's right.
And here there are 3 dying declarations. That is what is bothering us. And also the medical evidence overwhelmingly against you. You will have to demonstrate. See, it's not beyond reasonable doubt. Their defense is simple. We had gone for a walk. By the time we came, my another son, he had tried to save her. Along with the neighbors, he broke open the door of the kitchen. He entered. He saw his sister-in-law burning, and he was also burnt. He also suffered burn injuries. So now, from the evidence of those 2 witnesses who barged into the kitchen, along with the brother-in-law,
They do not talk about.
they say the father-in-law and mother-in-law came from outside.
Yes.
So now how? Their theory of they had gone for a walk, early morning walk, because this happened around 7:15 or 7:30 in the morning.
6:30 in the morning.
Huh?
6:30.
6:30. By the time they came back, it was 7:15 or 7:30 or 7 o'clock. It seems to be reasonable. And it is a peak summer also, April. They would have gone for a walk, stroll. And they continue to be in the hospital throughout.
They took her, in fact, the husband,
They took her, shifted her to the hospital, from one hospital to another hospital. So these are all cumulatively makes us.
The parents of the deceased and the brother of the deceased, who also in appeal today, have categorically said that there was a demand of a car and other things, and
But
she
they are not booked for 3 and 4 of DP Act. Only it is 302, 498A.
No, not only for spare care. Man's permit. We just try to
Please locate, try to
find the 16th
and assist us when we continue at 2 o'clock. All right? Madam, you also go through the records. Try to help us, try to assist us. If you find any difficulty, we will do it jointly. Don't worry. All right? How many years of practice you have put in? 2 years. Very good. This is a very good case. You can make a beginning. All right?
With my Lord's permission, may I mention item number 119? It is a criminal appeal. Because I'm taking some time in this matter. The record runs into 5,000 pages.
119. All right. After vacation.
May I please mention item number 111.4, Your Lordship? The arguing counsel is taken in the appeal.
111.4.
May I please note item 11.
They are batch matters.
Yes, please.
Let us see. Let us see.
I will find the petition and the.
We'll see.
Item 110. May I please note item 110. My lord, Senior Counsel R. Anand Fatima, sir, will going to argue for this matter.
Very good.
My lord, she is already engaged today in partner matter in court on 8. That will be continued post lunch as well. My lord, will give 1 day's accommodation.
We'll see. We'll see. When it reaches, you mention it.
Minus 103 passover item. We have gone through the document which has been sent to the Honorable Court. That doesn't contain what this Honorable Court needed. Actually, this court needed the juvenile justice board report, the file leading to that order. But in the order, it was mistakenly.
Mention when it reaches.
It is a passover item.
Mention when it reaches.
maybe we permitted to see whether somebody can be ready. This person produce the original record. The original records we can just
Yes, let them go through your shoulder. You can sit here itself. Don't take it out.
I'm so grateful.
All right.
Item 106. Raju.
May I just mention what 108 can be disposed of on board?
No tax 108.
Lordship, we don't have instructions from the client. Whole matter, they're not able to track it.
You are appealing. Appeal is by the revenue.
Can be posted immediately after, we're just seeking instructions.
No, what is this, madam? He is giving concession and it is in your favor and you are saying.
We just, don't have instructions.
We have instructions, don't worry. Suppose you are the appellant, then you would have been correct. He is the appellant. 3 matters.
Only one matter.
106.
108.
108. All. You have the monetary limit fixed under circular number so and so. Give that circular. And the tax effective in the instant appeal being less than the monetary limit fixed. Give it. The appeal is dismissed without expressing any opinion on the merits. So, Raju, how much time will it take? 1 hour? 1 hour. So we can come at 3:30. Others need not wait. Any submissions come at 4 o'clock. Yes, sir.
Yes. Yeah, the endorsed violation. So that should be.
Say something.
My lords wanted me to give a written note on written submissions. But what I have argued so far is this. Compilation is of what is referred to on delay. The copies. Copies. I'll quickly go through this because I've argued most of it.
No, not necessary. You have already argued.
Yes. Then only one thing, my lord, I would like to show is I would like to show one judgment which I did not point out. That is 2013 SCC page 1.
You have furnished it already?
It's a one volume, entire volume is judgment.
This is not mine. Where is my building? Where is my notebook? किसी और का है. This is not mine.
Page 1.
Yes, please. You want?
Paragraph 131.
So don't depend upon them. They will teach you like anything. None of the court officers
Supreme Court exists, don't depend upon them.
My note will be
Yeah.
It was argued that the speech was given by Sharjeel Imam. I have not done nothing in my speech. That was what was argued, Umar Khalid. Kindly have a look at paragraph 131. Please. 131.
Page?
Page will be 171. The topic starts at page 170, that is theory of agency and conspiracy. Kindly first have a look at para 130, then I'll take my note to 131. Few lines of para. Any important, my lords have got it? Yes. There is page 170, para 130. Theory of agency and conspiracy. An important facet of the law of conspiracy is that apart from it being a distinct offense, all conspirators are liable for the acts of each other, of crime or crimes which have been committed as a result of the conspiracy. Then, my lords, kindly come to para 131. Each conspirator can be attributed each other's actions in a conspiracy. So, Sharjeel Imam's speech attributed to them. Theory of agency applies, and this rule extended even prior to the amendment in the Penal Code in India. This is reflected in the rule of evidence under Section 10 of the Evidence Act. In Nalini, this court explained that conspiracy results in a joint responsibility and everything said, written, and done in furtherance of common purpose is deemed to have been done by each of them. Court held some of the broad principles of governing the law of conspiracy may be summarized, though as the name implies, summary cannot be exhaustive of the principles. Then, my lords, will see all the principles are laid down as from principles, my lord. Kindly come to subpara 7. A charge of conspiracy may prejudice the accused because it forces them into a joint plan and court may consider an entire mass of evidence against each accused. Prosecution has to produce evidence not only to show that each of the accused has a knowledge of the object of the conspiracy, but also of the agreement. In charge of conspiracy, the court has to guard itself against the danger of unfairness to the accused. Introduction of evidence against some may result in conviction of all which is to be avoided. By means of evidence of conspiracy which is otherwise inadmissible in trial, accused the substantive offense. Prosecution tries to implicate the accused not only in the conspiracy itself but also in substantive crime of the alleged conspirator. There is always been. Then kindly come to 146 and 147. 147. 147. After the lordship have extended section 10. From 147.1. 147 I read. It is to be seen that there are three conditions of section 10. One is before utilizing section and for admitting certain statements of co-accused from confessing, there should be a reasonable ground to believe that two or more persons conspired together to commit an offense or an accidental fraud. According to this section, only when this condition is satisfied in a given case, then only a question of utilizing the statement of an accused against the co-accused can be taken into consideration. Here, my lord, prima facie conspiracy accepted because the cognizance has been taken for 120p. Thus, as per section 10, the following principles agreed upon unanimously. Then there shall be prima facie evidence affording reasonable ground for the court to believe that two or more persons are part of the conspiracy to commit a wrongful act. Once this condition is written, anything said, done or written by any of its members in reference to the common intention will be considered as evidence against the other conspirators. So this is the difference. Therefore, Sharjeel Imam's case will be considered as evidence against the others. Review also, my lord, has been rejected. That is there in page 9, last line. Review against the judgment is rejected. Now I'll come to the rejoinder part. What is it? This landscape paper. This is part 2. This is I'm dealing with their rejoinder. But first they argue delay not attributable to them, then I've got a detailed delay note which is with it, so I'm keeping that. The place of
Where is the delay note given by you?
well, page 2 of my first.
What you have given today?
Page 2. Please kindly have a look at 9, my lord. Delay compilation which I've given is the other one which I've given, my lord. Prosecution is ready, however, we are ready to argue on this charge framing. Prosecution is ready. My lord, about point number 9, 11.9.23. Prosecution is ready, however, objected to by the accused persons that clarifies and when investigation will be completed. Objection learned PP recorded that since counsel were pressing this objection, the clients are on bail in this case, while other counsels in judicial custody will later on get bail due to the delay in trial. But this is there in my compilation page 1, my lords. This order is at serial number 1. The order which is referred to is serial number 1 of the second page. It order dated 11/9/23. So all this onward leads to delay, my lords. Now I tell my lords, as far as the one point which is required in case of
yes.
Other part is there at the bottom of page number 4, but before I come to that, if you don't argue a case saying that further investigation is pending, you are attributing it, the delay can be attributed to you. The reason is this: Constitution files one sheet saying that investigation is over, but there is some further investigation pending, and that Constitution file takes cognizance. That means court prima facie finds that there is an offence made out. At that stage, the accused can't say that wait for further evidence to come and then I'll argue on charges. We'll have to argue on the charges as the evidence that is produced and laid before the court. There are two judgments on this point. One is Devendranath Padhi, my lords. So essentially what they are saying is wait for other evidence to come. If other evidence comes, then there can be modification of the charge.
Because you, according to them, you are filing the charges intermittently, charge sheets.
No, charge sheet has been filed against different accused.
Yeah.
So separate accused. But if I file a charge sheet, my lords, you can't live. If I file a charge sheet and offence is made out, then they have to argue on charges. They may be discharged if there is insufficient evidence, but they can't wait for the. They can't say wait till the other evidence comes. That it may or may not come. But charge sheet was filed on 16/9/20, which is the first charge sheet, main charge sheet.
In which this Umar Khalid was a party?
Umar Khalid was there in the second charge sheet on 22nd November 2020.
So now he was not there in the first charge sheet?
Not there.
We brought him in the second charge sheet. And second supplement charge sheet was filed, he was already there.
He was already there. It was a technical charge sheet.
All right. But that is what you went, their grievance is that you went on filing one after the other. How do you attribute delay to me?
That filing of additional charge sheet has nothing to do with delay. The court can proceed with the case. Otherwise, the court would not have taken cognizance. The court has taken cognizance.
No, their contention is that the matter never reached the stage of argument before charge.
No, we were ready to argue whatever it is. Therefore, kindly have a look at what is to be looked at the stage of framing of charge, the documents which are accompanying the charge sheet, that's all. You can't look at something which is going to come and then decide the framing of charge.
All right, all right.
That is clear in Devendranath Padhe's case, my lord. Para 8 and 18. So essentially, what is their case? Some other evidence is going to come. Wait, decide my discharge application on some evidence that is going to come. That's not permissible. You have to decide on the record that is before the court or the date the court has taken cognizance. Now, kindly have a look at para 6 of this judgment, where section 227 has been extracted. My lords have got 227 discharge. If upon consideration of the record of the case and the documents submitted therewith, and after hearing the submissions of the accused on his behalf, the judge considers that there is not sufficient from proceeding against the accused, he shall discharge the accused and his reasons, and record his reasons for doing so. Record of the case. Now, what is record of the case? Kindly come to para 8. What is the meaning of the expression, the record of the case?
What? The only material question in this case was, can the trial court at the time of framing of the charge consider the material filed by the accused or not?
Yes.
They did not say that consider our material. They are saying that your material, you make up your mind whether you are filing.
Not come. That material may not come.
Then you say so. That is what is their contention.
That is not relevant for the purpose of discharge. That is what I am submitting. That is not relevant for the purpose of discharge.
Then the learned judge should have said so. That is what they are saying.
But we were ready. We were ready to argue the matter. We said that we are ready.
Oh.
Don't want to. Now kindly have a look at the first para 3, the order records. The learned public process is ready to begin the arguments on the point of charge. Therefore, there is no delay on the process, cases of process, part of the prosecution.
So from 20 to 23, they have made out certain stages, one stage 2, and
30,000 pages, they insisted on hard copies. We said, we give you soft copies. They said, no, we want hard copies. So I have given in detail in my first submission why delay is attributed. This I am additionally adding notes.
All.
Then my lords will come back to my reply notes. It is joined. So delay note I have seen. Then play of LLB not 8120 notes. On a statement, in reply, I am referring to statement of Tariq. I told Umar that flight tickets of 23rd of February is very expensive and I can book your flight 5-6 days later. But Umar refused. Relevant page number. Therefore, there was no need for him to leave. He deliberately left to create evidence that I am absent. And the purpose he wanted particularly, he knew that riots are going to take place, violent riots are going to take place. He wanted to create an alibi, therefore he insisted that he should go even if the tickets were very expensive. Which are referred to, my lord, this is all the documents which are referred to in my note. It becomes easier instead of going through the different pages. Say for example, when I said referring to statement of Tariq, it is the first item in this. So it becomes easier for my lord to refer to it. Then my lord, statement of Neon, page 124 of additional document, which is item number 2 in the compilation. Page 5, my lord, of this, where I have extracted the statement. Amanullah ने बताया कि 23/2/2020 की साजिश के तहत उमर खालिद दिल्ली में नहीं रहेगा और प्रोटेस्ट की जिम्मेदारी जेसीसी के पास रहेगी. So he wanted to deflect the responsibility on JCC, therefore deliberately made out a plan that he would go and leave Delhi. Then, my lord, ताकि उमर खालिद पे doubt ना हो. So this is only fabricating evidence. I leave at the right moment, knowing that this is going to happen, so that there is no doubt. I was not there. That would be the standard answer. But I'll point out where he was there later on. Then his role is corroborated in 164 statement of Beta, my lords, which is at serial number 3, my lords. Kindly have a look at page 6 of this witness Beta. इंदिरा तोड़ जामिया कंपनी के लोगों के साथ इशरत जहां, खालिद, सैफी और कुछ अन्य नाम जो मैं बता रहा हूं, यूनाइटेड अगेंस्ट हेड उमर खालिद, इन सब की प्लानिंग से हुआ है. कुछ जमात के लोग भी थे. ये जो लोगों को मौत हुई है, घर जले, प्रॉपर्टी हुई है, ये सब इन लोगों की प्लानिंग से हुई. So he attributes that the planning was done by Umar Khalid. He was one of the co-conspirators who had planned. Then, my lord, his next point is, these are all 164 statements, not in 161 statements, my lord. Then, my lords, kindly have a look at the third point which is raised. You are not an administrator, admin of DPSG group, did not send messages in the group, as only admin can send messages. This again is misstating. Kindly have a look at my reply, my lords. In my this thing, landscape paper. WhatsApp chat for deleting the WhatsApp messages of group DPSG and changing group rules to admin only was done on 12/3/2020 in pursuance of objective to delete and destroy electronic. Before 12th of March, he could post and delete messages. It is 12th of March that they brought in an admin and they said you can't delete it. Then he was not made an admin. Earlier, everyone could post messages, including Umar Khalid. This they have suppressed. But kindly have a look at page 7 of my the evidence. Causing disappearance by directing members to delete incremental chats and migrate to Signal app from WhatsApp. There are so many stages. Therefore, they then decided that delete everything from WhatsApp. At that stage, subsequently, he was not made an admin. But before that, no admin was required to post and delete. Now, kindly look at page 7, the first column. Third column in the first row. May I suggest that this group be deleted and all of you clear this chat. We can reconvene on Signal. Note relevant note that present FIR for Northern was registered on 6/3/20 and the first arrest was made on 9/3/20. These facts were revealed in public domain on 11/3/2020. And 11/3/2020 they migrate to Signal and get able to trace. They change the, and on 13th of March, kindly have a look. Everyone will have to individually delete chats.
Yes.
And important persons are removed from the group, my lords. That my lords may find on the next page, that is page 8, second last entry, 12th of March 2020. Sadam and Athar, they are all removed. So to dilute and to remove the evidence that they were involved, all this was diluted and deleted. Both are accused, my lords. Therefore, this fact that I could not operate the WhatsApp chat is only misleading, because till the crucial date, till the arrest was made, he could post and he could delete and he could. Then this was changed. Kindly look at the last entry at page 8. On 12th of March 2020, change this group settings. Sabha Diwan changed this group entry settings to allow only admins to send messages in this group. Prior to that, Umar Khalid could add messages. Therefore, the submission that no, he had no power to delete because not an admin is wrong. Only on 12th of March, after arrest was made, that they decided to change. Then, my lords, we kindly have a look at item number 4. In my note, there is a mistake. My lord, all of Umar Khalid begins an antecedent wherein he had said he was a harbinger of this slogan, my lord, Bharat Tere Tukde Tukde Honge, that is at page 9, which is part of my charge sheet, which is there at page 10 and 11, my lords.
Yes.
That entire FIR where this slogan was raised, for an anti-national slogan, that Bharat Tere Tukde Tukde Honge, was relied upon in this charge sheet, which my lords will find at page 11 of this second compilation. Page 9. Page 11, item 64. Almad of Honorable CMM Court at Patiala House Court, New Delhi, along with the case file of FIR number 110 of 18, PS Basantpur, North New Delhi. It should be 2016, 2018 is wrongly typed, it should be 2016.
Which one?
Item number 11, column number 64. Page number 11, column.
Which is that you are referring to? This one?
No, this one. No. Where this, when I'm referring,
What is orders?
Yes, when I'm referring to this, I'm referring to page number, the page number is here.
Page number?
Page number of this one, Manoj.
Only which one? Which is that page?
Page number 11. Not the other one, Manoj, this one.
The order sheets.
No, the other than.
We don't have. The other one is this statement.
Contents.
Yes,
that's it. But kindly have a look. This slogan, which was anti-national slogan, which was raised, was the subject matter of FIR 110 of 2016. We have relied upon it in the charge sheet at column number 6. Though there is a typo instead of 18, it should be 16.
Very difficult to maintain this tracing of all this because this practice we find only in Supreme Court, Mr. Raju. In High Courts, it is so beautiful, so excellent. Volume wise, it will be volume 1 till volume 50, 60, 70, 80, whatever. It will be running volumes.
Yeah, give the numbers to this. It will be easy. Just my lord, just hand it over to me. Just give me 2 minutes. I give the volume numbers.
No, it applies to them also. They also, like a magician giving from their hat, they'll keep on giving it.
My lords may only have to keep two documents ready, this one and this one.
Our difficulty starts when you stop. You means both of you.
I'm sorry, man. I'll see to it that next time it doesn't happen. But this is given 3 and this is given 4. So 3, wherever the pages numbers are referred to in 3, the relevant document is in 4.
No.
So that Bharat Tukde Tere Tukde Tukde Honge is part of the charge sheet. Then my lords may kindly have a look at my note number 3, where it was argued that there was no overt act apart from the speech. This is I'm dealing with Umar Khalid. I am not in protest side, scene of crime, statement and other evidences, witnesses are all hearsay. This was what was argued. First column, my lords have got it. In the next column, I've shown that how this is wrong, my lords. What was it? My lord, serial number 1, 5th to 6th of December 2019. CAP bill was introduced in Parliament. Consequently, MSJ was created.
We are not getting where you are reading which. You are reading this.
This one.
In this which page?
Second page,
In which, second page, which column?
Date is 5th and 6th, first line.
No, it is, there are, you have mentioned serial number.
Serial number 5, 6 and 7. Now my lord, we kindly have a look, my lord. First page. What they have argued in the first column. What they argued in the first column, what is my reply is in the second column, and what is the evidence is in the third, with respect to my reply, what is there is in the third column. My lord, you got it? Right, give me both sides to look at. So what was argued is 5, 6 and 7 in the first column. My lords have got it?
Yes.
What was argued? No overt act apart from speech.
Where do you get that no overt act?
That was what was argued by the other side.
Where do you get it?
Item number 5, 6 and 7 in the first column on the left at the second page. Five, 6 and 7 of the first column.
What is that 5, 6 and 7 refers to what?
Therefore, kindly have a look what they've argued.
Where do you get it that where they have argued?
The first page rejoinder.
Whose rejoinder?
Rejoinder of the other side. Other side rejoinder. I am dealing with the rejoinder of the other side.
This is the argument of the other side.
Other side.
All right.
In Umar Khalid.
Arguments on behalf of Umar Khalid.
Now, if my lord turns to page number, first page, it will mention on title, Umar Khalid is mentioned, my lords, we kindly have a look at first page.
Yes.
Umar Khalid is mentioned.
Yes.
Item 11.3, Umar Khalid, my lord. See, my lords have got
yes.
first page. This
yes.
is I am dealing with the arguments of Umar Khalid. And first column is rejoinder, second column is my reply.
So this no overt act, I am not in protest side. Statement of bond and other witnesses are all hearsay evidence.
It's argued by them.
So for this, which is your reply?
Reply is on the other two columns.
How do we know that it is other two columns is your reply?
Same thing. It is just running parallel.
Here it is only one column. Here it you have made it into three columns.
Therefore, I've segregated in different dates. I understand it's a lengthy matter, therefore I have to do it, try to do it in a very easy manner, but maybe I've not done it as. So on different.
No, you are instructing counsels have adopted a different policy, either convince the judge or confuse the judge.
No. It's the first policy, it can never be the second policy.
All right.
So, my lord, the second column shows the particulars. Say on 6/12 what has happened, 8/12 what has happened, 13/12 what has happened, and what is the evidence for what has happened is in the last column. It all shows that what they have argued in, as far as 5, 6 and 7 is incorrect. Say for example, kindly have a look at item number 2 and 3, my lords. 8/12/2019. Conspiratorial meeting for mobilization held between Sharjeel Imam, Umar Khalid and Yogendra Yadav. Actual interaction between Sharjeel and Umar Khalid. CAB was formed and Umar Khalid, Sharjeel Imam, Yogendra Yadav were members of CABT. What is the evidence? Photographs of the said meeting at page 95 of the additional documents. That photograph in my lords will find at page 13 of this compilation. If my lords want the ready reference of going to compilation, page 13. And CDR locations of Sharjeel and Imam corroborate these things, that they were present at that meeting. Then my lords may kindly have a look at the next date, 13.
No, FIR 55 of 2020
yes.
is all post 2019. What that has got to do with this? How are you linking that?
No, my lords may kindly have a look, my lord. This is the planning stage prior to 2020. The conspiracy always takes place before the incident. Therefore, this is the conspiracy. Conspiracy has to be prior to the actual act. Actual act. Therefore, this is a case of conspiracy, my lords.
Yes.
You can plan 2 years in advance, 1 year in advance. Therefore, page 12 and 13, but now, my lords, look at page 12 and 13 of the other volume. It will show these documents, which I have referred to in this note of mine.
Yes.
Then my lords may come to 13/12/2019. Umar Khalid is present at Jamia University when first phase of violence breaks out. Physically present with Sharjeel Imam. Further speech given by Sharjeel Imam at AMU on 16/1/20, reference to violence on 13/12/19 was mentioned as last Friday, 4 हफ्ते पहले की जो violence हुआ था. Umar Khalid directed Asif Iqbal Tana to form JCC. The same is not hearsay as protected witness. Bond was physically present. Umar Khalid told Sharjeel to start the Chakka Jam at Shine Bagh. Now, what is the evidence for this? What was stated here? Kindly come to the next column. Statement of bond at page 96 of additional documents. Instead of my lords going to additional document page 96 for ready reference, that statement is at page 48. So I made it convenient for my lords on page 14 of the next compilation. Then my lord, statement of bond at page 420 for additional documents by Umar Khalid. Asif Iqbal form JCC. Statement of bond stating that Umar Khalid also said to protesters that the government is Hindu government and he will throw them off at the right time. At page 426 of Umar Khalid additional documents.
So this is additional documents.
These are those additional documents.
Where is the heading for this as additional documents?
These are extracts of the additional documents I have given to my lords in a big compilation because I didn't want my lord to take out the pages and waste the time. Therefore, I have given it in a summarized way. I have extracted from the additional documents.
So there is that additional documents which is at file.
Yes, I'll give them. Yes. 291255 of 25. These are the additional documents. We have filed. Application for bringing on record additional documents. 291255 of 25. So instead of referring to those documents and time being wasted, I removed from there and put it here for ready reference.
What you can do is, it applies to both the sides. All your compilations.
Yes.
You, anyone, Mr. Dave, please tell any one of them will be nodal advocate. And they shall compile with all the 6 accused wise, name wise.
All the notes given.
Notes,
all the,
everything,
yes.
Compilations. One, after that, after Umar Khalid, then what is the Gulfisha? Gulfisha, then the Sharjeel Imam, one by one.
Yes.
And they you also, whatever you have given it, one compilation.
So whatever
running pages.
What is referred to here is one compilation, this other one, that's all.
No, see, as on today, you are now 1, 2, 3, 4.
The 4 is the earlier one which I've argued.
Whatever if you want to, otherwise you take it back.
No, I'll put it. My lords,
we want it in one compilation. Because it will be very difficult for us later on when we sit for to dictate the order, we'll have to collect everything.
So my lord want me to give submissions and the documents which are relied upon the written submissions in one compilation.
Citations, authorities, memos, that, this, X, Y, Z, whatever you have given to the court, everything should be in one compilation. Volume 1, Volume 2, Volume 3 or Volume 4, whatever it is. It applies to them also.
Bulky, my lords, I don't mind. I can become bulky, I don't mind.
We'll have a common index.
Unified. So, petitioner side 1 volume, one side. Side 1 side. It will be easy for us.
Yeah, complete and then give it.
This will go very, very like a wildfire.
The appellants will have a common index which will be each appellant wise.
Each appellant.
Yes.
Yeah, complete and then give it.
Yes.
Now, my lord, I'll do that.
You can complete it. Later on, you can give it.
Now, my lord, kindly have a look at the next one, my lords. 8 December 2019. That I've read, no? 13 December 2019. Also,
serial number 3.
I have shown no statement of bond, statement of
yes.
All. That is there in the second photo. Then my lords may kindly come to the fourth item on the page. 15 December 2019. First phase of riots at Jamia Nagar, where Umar Khalid was also present as per CDR data.
For this, is there a separate FIR or not?
Yes, there is. And Umar Khalid is not an accused. Umar Khalid is not.
I'm not an accused, but there is an FIR.
FIR is there.
In that, whether he is an accused.
He is not an accused. He was present. But I am dealing with this case saying that I was not present. Therefore, there is evidence to show that his CDR location and there are statements of witnesses who say that he was present. Therefore, his case that I was not present, I was nowhere present, is wrong. That is what I am trying to demonstrate. Therefore, physically present on ground as opposed to argument put forth. Then what is the data? CDR, his phone location shows he was there. Statement from Romeo shows he was there. Additional document, the page numbers are given. But instead of going to the additional documents, I am only referring to this compilation which I have given, my lords. That my lords will find statement of Romeo is at page 21 of this. Second. So it's convenient, instead of going to the additional document, go straight to the statement of Romeo first. Then it is further corroborated. Underlined portion is page 21, my lords will kindly have a look.
There is a translated copy. Have you furnished?
I can do it, but a Google translation can be done.
No, I can, if you read, I can understand. You convert it into.
I will do that. We have done that for the speeches, but not for the statements, my lord. Therefore, may I translate or read the Hindi version?
Read, you can read it.
Last full line. शार्जील इमाम ने फोन करके करीब 200 स्टूडेंट्स को जामिया और जेएनयू के से बुलवाया और 16/12/2019 तक पूरी भीड़ ने शाहीन बाग रोड को कंप्लीटली ब्लॉक कर दिया। इनका कहना था कि जब तक इस देश में दहशत और हिंसा और माहौल नहीं होगा तब तक काम नहीं चलेगा। हम दहशत और हिंसा इस कदर फैलाना है, हमें दहशत और हिंसा इस कदर फैलाना है कि मुसलमानों के लिए सरकार अलग राष्ट्र कर दे। Then on page 22, Sharjeel Imam admitted that he was a protest site. Everything can be seen from the consent print is electronic record in form of WhatsApp chat between Sharjeel Imam and his brother Raju. That is at page 23. Then, my lords, he was the master. He is connected with the mastermind. Umar Khalid is connected with the mastermind. हम दोनों mastermind हैं.
Where are you reading?
Page 23, my lord, the WhatsApp chat. So chat sent to his brother.
23.
23.
Where is it?
Second. Fourth line from the bottom. हम दोनों mastermind हैं.
No, it only shows okay, bye, John.
About that. One line above line.
I'm able to read it, brother.
हम दोनों mastermind हैं.
Not legible.
One line above okay. On the right side.
हम दोनों mastermind.
Then my lords will kindly have a look at the 17-12. JCC was formed pursuant to direction of Umar Khalid. All decisions came from Umar Khalid and nothing come as per protected witness James. This, my lords, will turn to my lord, page 24, where there is protected witness James is there. And the read page, this is the statement of James, my lord. Relevant at page 25, third line. The decisions of JCC used to come from Umar Khalid and Nadeem Khan.
Where are you reading?
Third line at page 25. The decisions of JCC used to come from Umar Khalid and Nadeem Khan, which were ratified in JCC by Asif Iqbal Tana and Saiful Islam. So decisions used to come from Lord the hands of JCC, he used to communicate. Then, my lords, may kindly have a look on 19/12/2019. Umar was detained for violating section 144 curfew orders which he disobeyed, unlawful assembly orders. He was actually present on ground during the first phase of riots. In contradiction to what was argued by petitioner, it was stated that he was not physically present in any protest. Now for that, the evidence is the DD entry bearing 30A dated 19/12/19, which is page 27 of this law. Five lines from bottom, his name is there. स्टेडियम से उमर खालिद एक प्रोमिनेंट आदमी था जो सभी के को स्टेडियम से रिलीज कर दिया गया था. It was prevented probably 151 or something like that. 44 violations were arrested in 151. Released. Detailed and released. Then, my lords, may flip over the page to page 4 of my page. December 20th, 2019. With the failure of first phase of riots, Jamia Awareness Campaign team created as per directions of Umar Khalid, that is protected witness James 164 statement, which my lords will find at page 28. ऐसी जामे बनाने के बाद अपने जामा एवेरेंस टीम बनाई गई थी, जिसके आइडिया आसिफ इकबाल तना और सैफुल इस्लाम का था. इन दोनों मीटिंग में कहा था कि उमर खालिद और नदीम खान चाहते हैं कि जेसीसी में जामा एवेरेंस कैंपेनिंग टीम भी होनी चाहिए. So Umar Khalid is responsible for creating this JSC. So then, on 26 December 2019, item number 8 at page 4. Meeting was held at ISI, Godi Road, where Khalid was physically present along with Khalid Saifi Nadeem Khan. DPSG was created of all the persons who attended the meeting. Meeting was attended by Umar Khalid. So and so, all of them are co-conspirators. During this time, anybody could have message in this group, contrary to what was argued, but only admins can send messages. Now this, my lords, will find at the next page, page 29. Now kindly have a look at page 29. What is the extracted portion? पीएस मीटिंग के बाद आपस में कोऑर्डिनेट और कम्युनिकेट करने के लिए डीपीएसडी दिल्ली प्रोटेस्ट सपोर्ट ग्रुप के नाम से एक व्हाट्सएप ग्रुप बनाया गया. इस ग्रुप को सभा दीवान ने दिसंबर 2019 में आखिर में बनाया था और राहुल रॉय ने इस ग्रुप के एडमिन थे. से प्रोफेसर अपूर्वानंद, देवागना, नताशा नरवाल, सीपीआईएम लिबरल से कविता कृष्णन, यूएस से उमर खालिद ये भी इस ग्रुप के मेंबर थे और काफी एक्टिव थे. I'm skipping the other names. Then, my lords, may see the CDR location. All these persons are part of DPSG and accused. All these persons were accused of also part of it. Some of them. Then say at the same page, CDR location number of so-and-so of accused Umar Khalid on 26/12/2019, the same corroborates his presence at the relevant time. Then my lords may come to the entry of second 28th of item number 9, 28th of December 2019. That I have covered. Kindly come to 2nd of January 2020, number 9. Second meeting of DPSG at Gandhi Peace Foundation. Umar Khalid and others are present at this meeting. Now this is said by protected witness Jupiter at page 104 of additional documents, but for sake of convenience I have extracted this at page 30. तो जनवरी 2020 30 I'm reading, right?
Yes.
2 जनवरी 2020 को गांधी पीस फाउंडेशन में राहुल रॉय की मीटिंग आई, जिसमें मैं भी गया, मेरे जुपिटर एडवांस। इस मीटिंग में राहुल रॉय, सभा दीवान, अपूर्वानंद, हर्षमंदर, योगेंद्र यादव, उमर खालिद, नताशा खालिद, सैफी, रजीव खान थे। इनके अलावा 20-30 लोग। So he was there in almost all the meetings. Then my lord, ये मीटिंग में जामिया और शाहीन बाग जैसी प्रोटेस्ट साइट बनाने को लेकर डिस्कशन किया गया और ये डिसाइड किया गया कि सभी प्रोटेस्ट साइट पर औरतों और बच्चों को आगे रखा जाए ताकि पुलिस कोई एक्शन न ले सके। So actively involved. Then my lords will flip the page, lords. 5th of January 2020. Conspirator, my lords, Taslim Ahmed directly texted to Umar Khalid to say, Umar bhai, protest shuru ho gaya hai. Therefore, he was supervising getting all the information. This WhatsApp chat is at page 2594 of the main charge sheet. But page 32 is the WhatsApp chat numbers. Taslim reporting to Umar Khalid about progress of women-centric protest in person. Umar bhai, protest start ho gaya hai. Chilam पर only girls protest और यहाँ के MLA भी चौधरी मार्टिन साहब यहीं बैठे हैं. Taslim is also an accused, my lord. 14 January also, my lord, cutting the message that Taslim gives to Umar bhai, Jafrabad, Silampur के regarding कुछ और बात करनी है. मैं तस्लीम सैयद आपसे बात हुई थी पहले भी 2 बार और मैं मिला भी था, आपसे प्लीज बात करिए. Other accused are talking with him with reference to this Jafrabad, Silampur, etc. where the Chakka jams have taken place. Then, my lord, 8th of January 2020, in this landscape paper, my lords will come down. I have several chats of Taslim and Umar, my lord. Now, kindly have a look at page 33, which I missed, page 33 of the evidence. On 22nd February 2020, the WhatsApp chat, my lord, got it, page 33, my lord, chat number 6. Taslim Umar Khalid about execution of Chakka Jam in furtherance to the criminal conspiracy. My lord, kindly have a look at what he says. आज रात 10 बजे जाफराबाद में रोड ब्लॉक कर दिया है. सभी वुमेन से अपील है कि ज्यादा से ज्यादा सपोर्ट में जल्दी पहुंचे और जीनत महल स्कूल जाफराबाद मेट्रो स्टेशन के नीचे भी पूरा चक्का जाम हो गया और दलित बहनें ने भी हमारे साथ है। एनआरसी सीए और सो खिलाफ उतर गए हैं और रिजर्वेशन के लिए भी रोड पे उतर गए हैं दलित बहनें। So this is therefore Taslim is reporting to Umar, and therefore whatever is happening, though he may not be present, but he is taking almost minute to minute information about the riots or the chakka jams or the protests which are taken place. Then my lords may come back to my landscape page, my lords. Item number 12. 8th of January 2020. Umar Khalid Shaifi or Tahir Hussain met a PFI office at Shaheen Bagh as per Saturn. CDI data, it will seem that all of them converged while arriving from different locations. No calls were made by any of these three between 7:58 to 8:54 p.m. And prior and post, the CDI location was very close. In Shaheen Bagh meeting, wherein Umar was present, protected the Saturn, which is there at page 108 of my additional documents, but conveniently extracted at page 34 of this compilation. CDR, if there is only a call made, the CDR location will be shown, otherwise it would not be shown numbers. The Saturn statement, my lord, is at page 34. It's a 164 statement, my lord. On oath. I'm reading the extracted point. मैं ताहिर हुसैन के यहाँ 4-5 साल से एक बार स्वयं मुझे बोला था कि उन्हें शाहीन बाग चलना है। वहाँ जब हम पहुँचे तो मैं बाहर रोक दिया उन्होंने और वे तो ऑफिस में चले गए थे। उसी ऑफिस में उनके बाद उमर खालिद और खालिद सैफी भी गए थे। तो शाहीन बाग मीटिंग was attended by him. Then, my lord, item number 13 of 23rd of January 2020. Secret meeting was held at Seelampur between Umar Khalid, Gulfisha Fatima and Taslim Ahmed. The evidence is photograph, which my lords will find at page 35 of this compilation. And I marked that Umar Khalid is there, my lords, in this photograph. And there is Gulfisha, Taslim Ahmed are also there. Then my lords may come to statement of protected witness Smith, which is at page 36. The 164 statement. यामीन का मकान E1 13 जिसे उन्होंने ऑफिस बना रखा था वहीं पर इनकी मीटिंग हुआ करती थी। 2000 को उमर खालिद का भाषण हुआ, फिर उस ऑफिस में गुलफिशा देवांगना और नताशा उमर खालिद को लेकर चली गई। मैं भी पीछे पीछे उनके गया था। मैंने देखा कि गुलफिशा, नताशा, देवांगना, सोहेल और सदाब और अन्य लड़कियां बैठी हुई थी। उमर खालिद कह रहे थे सीआरए एनआरसी के खिलाफ भारत सरकार को झुकाने के लिए भी हम तैयार हैं। हमने हथियार इकट्ठा कर रखा है, जिस पर सब लोग मिलकर बोले हम सब तैयार हो हैं। इनके इरादे खतरनाक लग रहे थे। ये बात सुनकर मैं डर गया और मैं वहां से बाहर निकल गया। Was present where they said we have collected arms.
Where is that? Page 37, is it?
Page 36.
36.
That is statement of Smith. 164 statement.
It is Smith.
Okay.
This is all recorded subsequent to the registration of the FIR. Yes.
Yes. During course of investigation. But 164 statements. Then, my lord, statement of echo, where I produced along with my additional document at page 111, but for convenience, I have extracted at page 37. They're actually present, they are witness to this, therefore there is no hearsay, but as was argued. Page 37, statement of echo. कौन क्या बोलेगा, किसको संचालन करना है, ये कुल बताया करती थी। जनवरी से लास्ट में जेएनयू वाला खालिद सीलमपुर आया, लोगों को बोलकर सीएए, सीएबी आर्टिकल 370 और राम मंदिर के मुद्दों पर पब्लिक को भड़काया। कुल और उसकी साथी, कुल का नाम गुलफिशा है, कुल के साथी सोहेल, सदाब, तस्लीम, देवांगना, नताशा, रॉय सुहासनी, उन्होंने यमीन के घर के नीचे ही स्वयं अपना ऑफिस बना रखा था। उस रूम में भी गया था सबके साथ। उस रूम में उमर खालिद ने बोला कुल से कि भाषण से कोई काम नहीं चलेगा, ये समझो कि सरकार मुसलमानों के खिलाफ है, खून बहाना पड़ेगा, ऐसे नहीं चलेगा। चक्का जाम ये आखिरी रास्ता है, हमें सरकार को घुटने के बल लाना ही होगा। This is what he has said. This is direct evidence of the person who has seen. This is not hearsay evidence. This is a 164 on oath statement.
Yes.
Then come back to the. Even ECO has said that at page 13 the Chakka Jam Karano, that is what Umar Khalid had said. Then President Trump came on 11th of February 2020. Then on 17th of February 2020, Umar Khalid gave the Amravati speech. I'm sorry, I skipped one date, but 10th of February 2020. Item number 14. Welfare Party of India protested Jantar Mantar. Head of this party is Umar's father, Ilyas. Umar met Jangirpuri ladies and said that you all come from Jangirpuri, where Bangladeshi population is more. Make them aware of CAE and make them fight against this law. There is protected witness Helium, whose statement have annexed at page 112 and 13 of the additional documents, and protected witness Krypton, whose statement have annexed at page 113 of the additional document. But for the sake of convenience, I have extracted those statements at page 40 of this compilation of the. Mr. Helium is at page 40, my lords. 10 फरवरी के सुबह को 4 बसों में बंदोबस्त किया, 4 बसों का बंदोबस्त किया, लगभग 250 महिलाओं और बच्चों को लेकर जंतर मंतर गए। वहां पर हमारी मुलाकात उमर खालिद और उसके पिता एसक्यू इलियास से कराई। उमर खालिद ने कहा, आप लोग जहांगीरपुरी से आते हैं, वहां पर बांग्लादेश के लोग ज्यादा है, उन लोगों के एनआरसी के बारे में बताते रहो और इन कानून के विरुद्ध लड़ने के लिए उनसे कहो। Then one of the next is protected witness Krypton. These are all witnesses who are seen in person. It is not hearsay evidence. Page 41, my lords. Again 164 statement before magistrate. 10 फरवरी की सुबह में 9 बजे 5 बसों में तकरीबन 250 लोग को लेकर जंतर मंतर वेलफेयर पार्टी के प्रोग्राम के स्टेज पे डॉक्टर एसक्यूआर इलियास और रियाज तालिब आरिफ अखलाक उमर खालिद और साउथ से आए हुए गेस्ट स्टेज पर थे। हजारों की तादाद में पब्लिक इस मीटिंग में थे। इसके बाद डॉक्टर एसक्यूआर इलियास ने अपने बेटे को जहांगीरपुरी से आने लोगों को मिलवाया और शोर में प्रोटेस्ट करने को कहा। उनके बेटे उमर खालिद ने भी जहांगीरपुरी के लोगों को कहा कि आप लोग बांग्लाभाषी है, अवैध बांग्लादेशी लोग रहते हैं, वहां रहते हैं, जब तक सीए विरोध नहीं लड़ेंगे तब तक यहाँ सरकार काला कानून वापस नहीं लेगी। Then my lords may kindly have a look at item number 16. Umar Khalid gave that Amravati speech.
We'll have to speed up, it is almost 3:30. By 10 minutes you'll have to wind up.
Then I'll go show the most important thing. Which one? Page 42, beta scale. Page 42, beta. ये लोग सारी प्रोटेस्ट साइट पर जाते थे, फिर एक दिन सडनली उमर खालिद अमरावती महाराष्ट्र में एक स्पीच देते हैं जो मैंने देखा है था, जिसमें उन्होंने बोला था कि ट्रम्प इंडिया आने वाले हैं, अब हमें सड़कों पर उतार कर अपनी ताकत दिखानी होगी। उनकी स्पीच में के बाद कंटिन्यूअस मीटिंग होने लगी जो कि जामिया कोऑर्डिनेशन कमेटी रूम में ही होती। अमानुल्लाह ने मुझे बताया कि मीटिंग में ये डिसाइड हुआ कि जामिया कोऑर्डिनेशन कमेटी के लोग पिंजरा टूट रिप्रेजेंटेटिव के साथ मिलकर चक्का जाम करेंगे नॉर्थ ईस्ट में। So all these things till page 8 disproves their arguments, but shows that what they are arguing is not correct. Then one statement which I have to read is, they say that they will give speeches, peaceful speeches from the stage, and real directions will come off stage. That, my lords, will find in pages 1689 and 1691 of the main charge sheet, which I have stated at page 8. Page, kindly have a look at page 49. This is the statement of Tango. This is statement of Tango. Tango, that my lords will find at page 8 of the landscape paper. Statement of 164 Tango. Tango statement is at page 49. Kindly have a look at about 8th or 10th line of page 49. इस्माइल हमेशा लड़ने मरने की बात करता था और नदीम खान जब भी प्रोटेस्ट साइट पर अपनी टीम के साथ आता था, स्टेज के ऊपर से कुछ और बातें करते थे और जब नीचे पर्सनली अलग से वॉलंटियर की मीटिंग करते थे तब कुछ और बातें करते थे। जैसे कि बातें होती थी कि यहाँ पर बैठने से कुछ नहीं होगा और सड़क पर उतरना पड़ेगा, 2-4 पुलिस वालों का खून बहाना पड़ेगा, इन काफिरों का खून बहाना पड़ेगा। काफिर कोर्ट क्वेश्चन, काफिर कौन? बिकॉज 160%। जो भी गैर मुसलमान है वो काफिर है, ऐसे भी बात होती थी। हथियार जमा करने होंगे और ये सरकार हिंदुओं की सरकार है और मुसलमानों के लिए कुछ भी नहीं सोच सकती। तब मैंने सोचा था कि गर्म खून का शायद आगे चल के ठंडा हो जाएगा। Then kindly have a look at statement of hotel at page 51. Relevant at page 53.
5 lines, 6 lines from bottom.
6 lines from bottom.
On February 15.
On February, my lord, got page 53.
Yes.
On February 15, during one such meeting, Nadim Khan had said, we will talk on the stage and appeal to everyone to conduct this protest in a peaceful manner. But in reality, we have to do chakka jam, and when the crowd gathers, we'll have to attack the police. We will stop this law, even if we have to shed blood on the street. If they kill one of our men, we will kill 2 of theirs. I will tell in advance the time when they will have to be killed. On one such night, Nadeem Bhai sent a message that during Trump's will shed the blood of police and kafirs on the street. Only then this issue is spread at international level. For this, it is necessary to do chakka jam at various places and necessary stones should be pelted to the police. And so, this is, then my lords, then kindly have a look at statement of Pluto, 17.8, where says weapons will have to be procured. What is that? Page number 59. Kindly look at page number 59. Statement of truth of the underlying portion. अब वक्त आ गया है दिल्ली में आग लगाने का। राहुल रॉय भाई का फोन आया था, चलो हमने सारी तैयारी कर ली है, हमने असले हैं, पेट्रोल वगैरह भरवा लिया है, पैसे भी हमारे पास कोई कमी, पैसे की भी हमारे पास कोई कमी नहीं है, पूरी दिल्ली को दहलाना है। जब तक 100-200 लोग नहीं मरेंगे, 100-200 जगह आगजनी नहीं होगी, तब तक हमारी मसला हल नहीं होगा। अब सब मिलके तैयारी कर लो, हमारी तैयारी तुम्हारे साथ है। रिजवान so. But then my lord, who was present is at page 59. Same page, first paragraph. Others, उनके नाम others, Sadaf, Salim, Salim Khan, all these persons. Therefore, it was a violent protest where they even gathered the arms. Show me the paragraph. But then what was argued was he is discharged in the case. That my lords will find my reply at page number 9. That order of discharge is not a discharge on merit. It is because he is involved in this case. Therefore, there is an overlap. Therefore, he has been discharged. Not because he is not involved. That order I have extracted, which is at page 9, my lords. So he says, I was discharged in that case. You are discharged not because you are not involved, but because there is an overlap.
Which page 9?
Page 9 of my landscape paper. Para 63 of the order I have extracted, my lord. As far as accused Khalid Shafi and Umar Khalid are concerned, I find that the allegation made against them relate to umbrella conspiracy rather than the conspiracy peculiar to the incident investigated in the case instead of Pradeep Party. We already discussed the scope of two different conspiracies here and above. Since umbrella conspiracy is larger conspiracy to incite riots in Delhi, is already subject matter of consideration. FIR 59, that the present FIR is to the accused entitled to discharge. Not because they are innocent, not because they did not take part, but they said you are part of larger conspiracy, not part of the smaller offense that took place pursuant to the conspiracy. The parity I have already discussed, my parity note is there. Change in circumstance also I have discussed, which is there in my other note, where I gave the written submissions of what I have argued. Now, there one submission which was made in regard to change of circumstances, Varnan's case. It was argued that Varnan's case has come subsequently, therefore there is a change in circumstance. But the principles that were there in Varnan were already applied by the trial court and rejected. Therefore, there is no question of Varnan not being applied. The principles were applied by the trial court. First note is I have dealt with Varnan in page 10, where I have dealt with no change in circumstance. I have dealt with Varnan. So that will answer the question. Item 11 at page 10 deals with Sharjeel Imam, my lords. What is argued, page 10 of the landscape paper, my lords? Item 11.1 Sharjeel Imam is argued no evidence in instance apart from.
Where are reading? Which page?
Page 10.
11.
10. Para 11.1.
Yes.
The title is Sharjeel Imam. What was argued is no evidence instance apart from speech. I have shown in the right hand column what is there other than the speech. If my lord wants, I will take my lord to that, but since there is paucity of time, I am not taking it. Then it was argued that he is not a member of DPSG group. I have shown that he formed other groups. Maybe he is not there, but he has formed other groups. Then, my lord, he has given an intellectual terrorist comment that I have dealt with in his speech. I have pointed out, I have played the speech. I have showed that in his speech he said the constitution, what is the constitutional way, constitutional spirit, कुछ हो सकता है हद से ज्यादा इस डॉक्यूमेंट का भरोसा करना है हमारे लिए तो doesn't believe the constitution that if you follow the constitution it will be suicide. That is what he has stated in his speech at page 63 of the compilation which I have given. That is there. So each of the submissions I have dealt with. Then Gulfisha Fatima is the next one at page 11. The arguments, first argument, regime change was not argued even before. This is wrong, my lords. This is there at page 2688 of the main charge sheet. Now, then, my lord, I have shown that WhatsApp chat stating protest, people in protest are many steps ahead of political formula. Ultimately, call for regime change will come from states. That is page 1 of my document note. Statement of bond and statement of Romeo is at 164 statement, page 1583 and 1587. Then parity note covers the parity as on merits, my lord. Apart from that, there is FSL report from cloth of police officer showing that assets were used. 164 statement is protected with status chilling powder was provided. Protected witness Smith and Shearer. Acid, chili powder, etc. provided by Gulfisha. Statement 164 statement of Sierra, which is at 112 of the additional documents. And that is at page 66, 67. Is the FSL report. Where is Sierra statement? Sierra, I missed Sierra statement, but I put it because I missed it. Therefore, she is actively involved, my lord, that as far as Gulfisha's role is concerned, I have extracted it at page 164 to 176 of the counter, 206 to 221 of the additional documents. Then Salim Khan, Sign welfare judgment. Sign welfare judgment is a Tata judgment, my lord, where the issue of delay was not, the issue of delay having been caused by the accused was not an issue. And my lord, Tata, the principles are different, my lord, the 28 is slightly different from 43T5. I've referred to it now, my lord, Shadab Ahmed, the last person, my lord, because it was filed subsequently, we could not file a counter, but many incorrect statements have been made. So I'm sorry to say that. Kindly come to page 13 of my landscape. The first statement was made that witness Silver stated that petitioner was present at 11 am 24 to 2020. Witness Silver doesn't state so, that he was present at 11 am. That appears to be a figment of imagination. No such statement is made by Silver, my lords. Relevant page is 360 of SLP of Sada. Mention of Sada, but no time is mentioned. Therefore, it is incorrectly stated that Silver told that petitioner Sada was present at 11. The second is the claim is witness Gold stated that petitioner was present at 1 p.m. on 24/2/20. No time is mentioned. But what is stated is afternoon in page 356 of SLP. Therefore, this is also an incorrect statement made. It was Head Constable Sunil stated petitioner was present at 1 p.m. on 24/2/20. No time is mentioned regarding the presence of petitioner can be confirmed from page 330 of SLP. So this is also an incorrect statement made. Then the fourth statement which was made is Constable Gyan stated that petitioner Sada was present at 1 p.m. on 24/2/2020. No time is mentioned. This can be confirmed from page 340 of SLP. The witness Constable Sunil stated that petitioner was present at 1 p.m. This also is incorrect. No such time is mentioned. Whereas CDR location of phone is not relied upon as far as Shadab is concerned, but we are relying on statements to show that he was present in the site. But then he talks of delay of recording statement. There was COVID, there were large number of riots. We had to examine statements also, so there was delay in recording statement. contradictions in subject matter of trial, role of Shaddam is there.
What do you say about section 15 of UAPA Act? Take out.
Yes.
How do you bring conspiracy within section 15 of the Act?
Section 18.
15.
UAPA Act. Terrorist Act.
See, you have invoked section 13, 16, 17, and 18.
Yes. Whoever does any act with the intention to threaten or likely to threaten unity, integrity, security, economic security, and sovereignty of India, or with the intent.
Because section 16, punishment for terrorist act. Whoever commits a terrorist act. So what is terrorist act is defined in section 15.
Yes.
How do you bring it under section 15?
Yes. I have referred to the speech of Sharjeel.
That's what. For speech, what they have contended is it's section 13.
No, my lord. Speech followed by action. 53% were killed.
What action?
Was 53%.
How do you link it that to this?
After 4 weeks, something is going to happen. That was said. After 4 weeks, the violent protest took place.
It's only a speech. That is what they're contending. It's only a speech.
No, it's not a speech. At the means of speech in ISO, this speech gives an idea of what was planned. There were conspiracy meetings. Those meetings were decided that the Chakka Jam, there will be violent
conspiratorial meetings would fall within the mischief of section 13. That is what Mr. Siddharth Dave said.
But 13 is punishment for unlawful. These are not unlawful activities. Because the speech says that you separate.
That at the most, what he has said, at the most, it may attract section 13(1)(b).
No, I'll tell my lord why 15 will be attracted only also because likely to threaten unity, integrity, and security of India because of isolation of Assam. That is one part. Secondly, economic blockade of areas, that is part of 15. Kindly have a look at the economic part, my lord. Section 15 is talks of economic security. My lords have got it.
So where do you get it?
Section 15. After amendment. Whoever does any act with the intent to threaten or likely to threaten unity, integrity, and security, that I am covered because you make speeches saying that Assam is to be separated, chicken neck is to be broken. That I am relying on this for the first part. Second part, I am relying economic security, threaten the economic security. Now, economic security, my lords will come to my lords. The definition of economic security, 15(1)(a)(3), disruption of supplies essential or service essential to life or community of India or any foreign country. Now kindly come to 2EA, my lord, section 2EA. Economic security includes financial, monetary, and fiscal stability, security with production, distribution, food security, livelihood security, energy security, ecological and environment. So food security, distribution of food will form part of economic security. When you want to do Chakka Jam, stop all the essential supplies. I've read and showed that they wanted to do Chakka Jam, see that Delhi is deprived of essential supplies. There would be economic security would be affected. And kindly have a look at 15(1)(a)(3), my lord. Now, see, my lords, may I read 15 all over again, my lords. Whoever does any act with intent or threaten to or likely to threaten the unity, integrity, security, or economic security or sovereignty of India, or with intent to strike terror or likely to strike terror in the people or any section of the people in India or in any foreign country. So, my lords may say everything is disjunct. Any act with intent to threaten or likely to threaten the unity, or integrity, or security, or economic security, or sovereignty of India, or with intent to strike terror or likely to strike terror in the people or any section of the people in India or in any foreign country, by using bombs, dynamites or other, as demonstrated, petrol bombs were used, firearms were used, the charge sheet on Arms Act, etc. or inflammable substance of firearms or other lethal weapons.
No, you are not attributing, Mr. Raju.
Any substances.
Mr. Raju, you are not attributing the use of these things against these persons.
No,
your charge sheet.
I'm sorry, Malad. I am not arguing the substantive case here. I am arguing the case of conspiracy. The conspiracy in the attribution of use of these bombs are there specific cases, substantive cases, which are large number of FIRs. It's a case of conspiracy. Conspiracy where you are made a conspiracy to see that these weapons, petrol bombs are used to carry out various incidents. I am not arguing the substantive offense. I am arguing the case of conspiracy here. So the other side has mixed the case of conspiracy and substantive offense. It is not my case that petrol bombs are used. As if petrol bombs are used, therefore I filed separate FIRs. The separate FIRs are taking charge of those cases. But the conspiracy is to use this. So you are part of a conspiracy which has, the furtherance of the conspiracy is to commit all these different acts of right. That is my case. Therefore, the confusion which the other side is trying to create is no petrol bombs were used as part. The conspiracy was to use the petrol bombs which they have used. For the use, the separate case is there.
All right.
Apart from speech, there are so many other things that are stated at page 10 of my landscape paper. At 2460 of the main chart, it shows what is the injury, how many people are more than 530 people have been injured.
That you have told me.
Therefore, it is not as if that it was only a mere speech. Your conspiracy has caused so many other incidents. It's not only speech, there are other parts which are still demonstrated in my note. And even preparation, my lord, is an offense under Section 18. But this is far ahead of preparation.
Word. The remedy is appearing for the respondent.
What was stated in the rejoinder has not been met.
That is what you also did.
I said in the beginning that they will not, their style is, they'll argue the rejoinder as is the main.
The learned advocates appearing for both the sides, having argued for a considerable length of time, have produced tendered authorities, memos, short synopsis, long synopsis, written arguments, charts, graphs, list of dates, list of events,
list of sizes.
As and when oral arguments was tendered. For the purposes of convenience, it was taken on record, and now the arguments having been concluded, we call upon the learned advocates appearing for the petitioners, from amongst them shall entrust the said documents to be collated, collected, and compiled in one single convenience compilation for the purposes of convenience of the court. Full stop. The same would also equally apply to the learned counsel appearing for the respondent T/S, who shall also compile the same and file it in the court for the convenience of the court. The said exercise shall be undertaken and completed on or before. Please tell us what date.
At least 10 days for the
2 days.
Choice is yours. You tell us, I will note down. That's all. This Friday?
Yes.
10 days. 10 days will be required. If I give by Friday, I'll give by after 1 week after the review.
Mr. Raju wants a rejoinder even to wants 10 days.
Is not come on record.
Some of what was submitted today. But some of what was submitted today was not even in the counter.
Correct to the charge sheet. Counter is not
Correct,
recorded in mail matter.
But
One has to argue.
the rejoinder given by us was not met.
Whatever time Mr. Raju takes, it's a submission from our bill. Yeah.
Sorry?
So Raju said
You want a further argument?
No. Raju said tomorrow he'll submit.
Say whichever date
No.
I'm just testing him.
No, tomorrow.
Not tomorrow for submission of the compilation.
No. You'll be able to do it by tomorrow.
Raju said he wants it.
No, I was just testing.
He was testing me again. He had been testing me. Today, thankfully, I wasn't tested that much.
You are not only being tested by him, but tested by other 5 also.
By Wednesday,
You seem to be the punching bag. No.
Maybe it's my nature, my question.
No. Or it can also be said you are capable of taking it.
Right.
My lords will next month.
Or we'll do one thing. We'll say on or before 18th. So that you can also have some within. And during vacation we can.
Yes. He indicates you are checking to find from our side.
Board of Council, this so and so. On behalf of petition. Take out. Please give a name. On or before 1812. For convenience compilation itself.
No, I know. It's an inconvenient company.
No.
It is inconvenient to them.
They can just buy it's over now. Just wait. You are very judgment.
Grateful, my lords, for a patient hearing.
Yes. 498 and 302. Tomorrow we'll continue tomorrow.
It's the top of the board, man.
Yes, first pattern. Immediately after the preliminary work is over, we'll take it. But
We'll do that.
it looks like you have a bad kids.
Because I mean, so the fact is that there is a homicide death.
Huh?
The death is homicide. Within not even a year marriage.
It means
The smell oil.
it is suicide or homicide. That you will have to establish. It's very difficult. You know of that. So we'll continue tomorrow. All right?
Very well.
Lordship, may I mention item number 111.4
What do you want?
in accommodation, your Lordship, for post vacation.
Wait.
Lordship, the main counsel is not well. He took ill in the morning. He won't be able to come tomorrow. He has a very sore throat and a fever.
So next week also is not coming.
Next week is possible, your Lordship.
Note down his name. If he's seen,
Yes, your Lordship.
he's not to be seen in Supreme Court for another 10 days.
Definitely.
Note down that number. Which is that number?
111, your Lordship.
Top of the board.
Let's get into